Okay, here we go. Apologies to everybody, but the tech hopefully will be all set. Won't have any more issues for the rest of tonight. Thanks for joining us. This is estate planning, not just planning for parents, estate planning. We're going to go through a lot of technical stuff, a lot of documents that you should be thinking about, stuff that you should be gathering, thinking about dealing with as you go forward here. Real quick. Just an introduction to us. My name is Tom Alessi. I am an investment advisor. I have been doing this now, God bless Craig, into my 27th year.
Wow.
Um, I'm a certified fiduciary when it comes to dealing with investments and investors, which just means that anytime I'm sitting down with somebody, I am compelled to act or bring up what I feel is in their best interest. You can ask me about anything you want, but I'm only going to bring up what I think is in your best interest. Craig, if you want to introduce yourself.
Yeah, so I'm Craig Richardson. I've been in investment for the last 24 years, and I specialize in working with families and individuals to help them to find their financial goals and have a better relationship with their money.
And Craig will be chiming in as we go along through this. Real quick, just about us and who we are. So, the Moody Street Group, for those who know Moody Street, we're not in Waltham. Technically, we're located in Newton. It's a little funky. It's literally the front door of the building's in Newton, the back of the property's in Waltham. So, we're right on the line there. Um, uh, when the started, oh, God bless, 15 years ago or so now, that created a what is known as the Special Needs Resource Network. We dedicate a portion of the firm trying to work with families, organizations like Charles River Centers to be that support piece for families when it comes to planning. I will tell you, as part of this, just as a little housekeeping, Greg, we are not attorneys. We are advisors. However, we feel that sometimes that gives us a little bit of an advantage because we can be more plain spoken as we talk about some of this stuff and be a little bit more relatable to some of the documents and material that's needed.
I'm glad you told me I'm not an attorney. I was confused. So,
Yeah, well, you're on TV, so sometimes you can be confused on what you play here on TV. Yes.
done, done.
So that
Yes.
in terms of what we do. Okay, so let's get into this. Let's get right into, considerations when we talk about and estate planning sometimes throws people off, Craig, because they think, oh, wait, that's, McMansions and all of this stuff. But really what this comes down to is, really the ins and outs of who's going to get your stuff,
Hmm.
regardless of what you have.
Right. Yeah, the state doesn't have to be a certain size. I mean, the back 40 can be 40 square feet. Doesn't have to be 40 acres.
Correct. And a mule.
Half a mule. Right.
And most importantly, as we talk with parents about this, right, this is that ongoing, who's going to handle your affairs later in life, specifically if you are no longer capable of handling them, or you unfortunately have passed away at some point in dealing with all of this.
Mhm.
The tax liability comes down to the amount of assets that you have, right? But, some of this is, hey, I'm passing assets, Greg, from one generation to another. I got to be thinking about that in terms of the liability and what's going to happen there.
Right. Yeah. I mean, estate taxes may not come into play, but taxes on retirement assets could. So there's always some kind of estate. With settling the estate in general, there could be taxes involved. Yep.
Right. And then what's the most efficient way to do that? How are we handling that? What's the planning aspect there? A lot of times this gets left right to the end. We just what's left at the end, well, we're going to pass it regardless of how that's going to affect the person who's receiving it.
Hmm.
And what's the best setup? We'll talk about that when we go through this a little bit in terms of setting it up and the ramifications that go along with that. And then lastly, and I know I apologize, there's a lot of words on the screen, but this is a big overlapping and umbrella kind of idea here because when we start talking about, beneficiaries and dealing with I'm future funding or thinking about leaving money out into the future for my child, my beneficiaries, but what happens if I have to use all those assets? Then what do I do?
I don't know. We'll talk about that.
Exactly.
That's why we're here.
Yes. So what happens if you don't have a plan, right? What happens if I haven't done anything? I haven't thought about this. I'm just, sort of letting it roll. right? Well, the law basically determines, right? A family court, and we'll go through that with the different ramifications of how that all works and what's there, right? If there's no decision maker in your life and you become disabled or incapacitated, then a lot of whatever has been set up or thought about stops. Like if you've been writing checks for something and now you can't write them anymore, that stops.
Yeah, people make a lot of assumptions, which we'll go through too, on who has authority and who doesn't have authority. Yep.
Yes, absolutely. Right. And then, again, Craig mentioned there may not be an estate tax in this, and again, great scheme of everything, but there could be exposure to other things that is, i.e., care that's necessary for an adult as we get older. And there's really no control over who's managing your assets. You're not designating anyone to handle that.
Mhm.
So there's a lot of considerations and reasons why, and I think that's, Craig, the importance of this, and I think what mostly is going to come from this for all those audience and listening is that a lot of this is yes, dealing with my own end of life situation, right? A lot of us don't want to have to face that, end of the line scenario.
It's not the fun dinner conversation, or
Yeah, no, it's not a fun conversation, but I think it's considerations and things that really need to be addressed and thought about to go through, right? So and part of that is to thinking about, well, what I have and how is that going to be transferred or how is that going to be inherited? And so this is just real high overview, and we'll go through each of these as it goes through, but a will, and we'll talk about a will in some detail because that is really like the jumping off point, Greg. That's like the starting
Mhm.
block, if you will, as you're building everything out from there.
Yep.
But then you have beneficiary designations. These are very, very important because beneficiary designations, in most cases, will override whatever the will says.
Right.
So if your will is saying, I want to leave everything to, Susie, but the beneficiary named in your retirement plan is John, John's getting it, not Susie.
Right, because like it says right here, one is contractual and the other is not. So beneficiaries who are named in a specific contract that overrides the will.
Right. There's joint ownership. So if you have a piece of property, you're married, maybe you bought it, the two of you, you're both on there, you joint ownership, right? One of you passes, the other one still owns it. That's the joint ownership in terms of that. And then there are trusts, right? And the trust really is the conversation that we're having here when we start talking about some of this and getting into why supplemental needs trusts are important, what they mean, the different types of trusts, and we'll go through that and walk through that. But on a high level, this is sort of how the money transfers, right? I name person in a will, or I designate some asset to go to somebody in a will. I've named a beneficiary. I own of something with someone else, or I put stuff into a trust and the trust is distributed. High level overview there, right? In terms of going through it. It's like passing stuff around. So what are the documents overview? And again, we'll go through each of these, but what we're going to cover for you are sort of those basic elements. The will, power of attorney, the healthcare proxy, HIPAA release, and living will. We sort of lump them all together, right? So we'll sort of talk about all of those together, and then we'll go into the trusts.
Mhm.
The will, Craig, this, it's almost easier to talk to someone who doesn't need a will than someone who does need a will. Because like everybody pretty much needs a, if you're married, if you have children, and clearly you're on this call, so you probably have children, whether or not you're married is a different conversation. You need a will, right? That's what it comes down to,
Hmm.
right? So if you got stuff, you need a will.
That's right.
And that's pretty much because the will is going to control the disposition of your assets. It's
Hmm.
going to name somebody to carry out those wishes, and it's going to designate a guardian. And this is something that comes up for children under the age of 18. You're designating a guardian. Whether they're special needs or typical, it is irrelevant because they're under the age of 18.
Yeah, a minor is a minor. For everybody that's irrelevant. If they're under 18 years old and you want to know if something happens to you, who's going to take care of my kids?
Right.
And you want to be spelling that out. if you can.
And there are some potential tax savings. This is more of dealing with probate and how it's designated and going through that part of it. But at a basic, this is letting everyone know this is what I want to see happen with my stuff.
Yeah, because I know I've been in a position where people who've passed did not have a will, and you're left trying to figure out what they're going to,
Right.
and that can be a real mess.
Yes, and it gets even more so when we start getting into some of the aspects of this. Like, okay, as you said, the court is deciding where those assets are going. If there's some precedent to law, to state law that will override anything, the court's going to name an administrator who's going to handle that. You're gone at this point, but the family has no control.
Yeah, I mean, the court is still going to decide where your stuff goes, but a will is going to tell the court where you want it to go.
Right.
So it kind of helps with that process. And what you said, there's the savings because it's spend a lot less time trying to figure it out.
Right. And then most importantly, when we're dealing in the subject matter and certainly talking about a child who's differently abled or has a disability, the court's going to appoint the guardian, right?
Mhm.
That's out of your hands, it's out of your control. And that is something that really precedent needs to be stepped in. It definitely needs to have a conversation about who the guardian is going to be.
Yeah, I mean, like I said, especially if you're not making that well known and communicating that with the person you want to be the guardian, it's going to go to family court and in 10, 15 minutes, they're going to decide who's watching your child. If someone
Right.
steps up, they may be that person. If they don't, it could be foster care. So just something you want to not leave open.
Right. Exactly. And then, without a will, basically, the state intestacy laws, it, pretty much, as Craig said, it goes to family court. And family court's going to decide who's going to raise the child and where they're going to be raised. And that's something that you really want to have control over.
Yeah, the other thing that says here too, the state intestacy laws may leave assets outright to your child with special needs, which you don't want to see happen, right? Because it doesn't take into consideration whether your child has a special need or not, or is getting disability benefits. It
Right.
only takes into consideration they're the next in line to get these assets. And so, boom, they get them.
Yes. Yeah, and that is a great point in terms of going through that and just making sure aware of it's very important. If you don't have a will, get one is the conversation here. And that's the starting point in the whole process. Uh, Generally, if you sit down with an attorney in today's world, you're going to not only be instructed to put together a will, you're also going to be instructed to put together a power of attorney
Mhm.
that would they will put together what is known as a general durable power of attorney, which says that the power of attorney comes into force when you are no longer capable or able to make decisions.
Right. This is usually medically incapable, not like I had a really bad buzz last night and can't think
Yes,
straight today.
right. I can't think straight right now in terms of going through it, right? But what you're giving is somebody else to act on your behalf. You're
Mhm.
giving somebody who has the right to then sign checks, pay bills, do things for you. So this is something that while it's important, should not be done lightly.
Yeah, because when you turn over durable power of attorney to somebody, they are you. They act as you. They can go into agreements. They can sell property. They can take money out of accounts. Now, one of the big misnomers here, though, is that a lot of people believe because they're married that that automatically applies to the spouse, that they can just sign for them and be their power. But you have to have that spelled out power of attorney, just like
Right.
anybody else.
Yeah, absolutely. And that's correct. That is something that does come up every now and then. Like, what? We're married. I can do this or I can sign off for them. No, that's not correct as far as the law is concerned. So again, that's why a lot of attorney, I mean, every attorney nowadays, if you go to a will, they're going to put a power of attorney in place as well.
Mhm.
Just know that it does change. And some of the stuff we will bring up, we'll talk about different locations. Everything we sort of talk about right now is sort of Massachusetts centric, but different states handle things different ways. So it may be okay, you're here now, but in the future, your plan may be to retire somewhere else. So you just want to make sure wherever that location is, whatever the jurisdiction is, that they're going to be either accepting or you're putting together what's necessary for that location.
Yep.
The other thing that they're going to give you, certainly here in the state of Massachusetts, is a healthcare proxy. So it's a will, power of attorney, and a healthcare proxy. Because in Massachusetts, they don't recognize a living will, but if you were in Vermont, they recognize a living will, they don't recognize a healthcare proxy. Again, depends on the state and where you are and how that all works. The HIPAA release, this is something to consider for everyone in your family because this gives you the ability to consult with doctors and physicians for, like Craig said, I can't have a conversation with my wife's doctor unless I've got her signing a HIPAA release for me.
Right. Now, sometimes, they may do it anyway, but that's at the doctor's discretion and they're kind of breaking HIPAA if they do it. So, um, don't make any assumption. Even like, so you have a minor child who's turning 18 and you're still caring for them, you can't talk to them just because you're the guardian. You got to have the HIPAA release.
Right. So, I mean, it's one of those things that again, it will probably be recommended to do the HIPAA release. But certainly if you're thinking about it, child's going away, you talked about this with kids going to college, right? Like if something happens at the college, I can't have the conversation with the doctor at college unless I've got a HIPAA release on my child. So it's something to consider for everyone. But in Massachusetts, what you're going to get is a will, a power of attorney, and the healthcare proxy. Where we get into some of those unique parts, unique pieces to special needs planning, special needs preparation. We talked last time in the last presentation about the letter of intent. We talked a little bit about guardianship and how that works and what really should be done. And then financial security is getting into the whole trust conversation. So again, Craig, if you just quickly want to go over, because we did cover it last time, but the whole letter of intent for folks.
Sure. So once again, just to go back through it real quick, I look at this as kind of like the owner's manual you wish you had when your child was born, right? It's all the information about what makes your child tick, what their routines are, what their favorite, activities are, their friends, their social life. But really important is, their medical information and their doctors and, who they use for different services. And then more importantly, even legal and financial information, as far as what's relatable to them. If they're getting disability benefits, that information in there. If they are, part a beneficiary on a trust, is that information labeled and where does that find it? That who the trustees are, caregivers, if there's future guardians, all that information you want to put in here. Like I said, if I was going to not be able to talk about my child tomorrow and someone just had to meet them for the first time, what information would I want them to be aware of?
Right. Right. It's not a legal document, but it's important. And it can be when applying for things like guardianship or naming a guardian and other things like that that can come into play. So
Mhm.
it's recommended to have it to along with any documents that you're trying to do or trying to use. And one of the things with this, as we always say, is this is not a static page. This is a morphing document. The child's growing, changes. The likes they had last year are not the likes they have next year, type of thing. So it just gets updated. Whether it gets updated at a certain point in time, their birthday or some other date that's important, it's up to you. But it's something that should be added to and just constantly going. So think of it. What did they used to have those things? Like baby book? Is that what they used to call
Yeah,
those things?
baby
Right?
book,
The
right.
baby book, like it's kind of like an evolved baby book, but the idea is not a baby book, but it's like Craig said, it's this ongoing, but it's a letter of intent that lets anybody who's looking at it get more insight into your son or daughter.
Yeah, it's not just in case you pass away. What if you just decide to go on vacation without that child and someone else is taking care of them for a couple of weeks, right? Now they've got all the contact information if something should happen. They know what the routines are in case they're not used to that. So, like I said, it's just a great tool to have when you're dealing with any child, but in particular when you deal with a child who is
Right.
differently abled.
Guardianship. And I read this quote last time because really for us it does summarize and sort of, you know, put together the whole thought is guardianship is the only way I can make sure that his mom or I will be able to advocate for what is necessary so he will be safe and happy. To secure this, I must prove to a court that my son is incapable of making decisions on his own. My wife and I must also choose someone to accept this responsibility when we are no longer alive and who we can trust to carry out our wishes. That summarizes the whole concept and scope for what guardianship is really about. Because really, what we're talking about, Craig, is that you're a fiduciary. It's a fiduciary relationship. You are managing the person and the estate of another individual,
Mhm.
and that's really what it means. It means I'm going to go above and beyond. Now, we understand as parents, we do that with our kids. Maybe we do it a little too much sometimes, but we do it with our kids. But now we're talking about maybe somebody else who's going to be stepping into this role and what they've got to be responsible for. Like the quote said, we've got to have somebody who's going to accept this responsibility
Mhm.
and carry out our wishes.
Yeah, they're both willing and able. Those both those factors need to apply, right?
Right.
Hmm.
You know, so it's important when we're dealing with minor kids, our own, typical children versus a special needs child. But the same concept comes into, okay, the child's now going to come of age, 18, then now they are an adult. And the rules change as we get to adulthood in designating guardianship.
Hmm.
And we just had this conversation, Craig, with an estate planning firm that we work with, where everything had been put in place, everything was set to go, except for because of some drag or lag in the courts, the child turned 18 in the process
Hmm.
and then just decided no and basically tore the whole thing up and said, no, I'm not going to go through with it. I'm not going to let it happen. And so now
Hmm.
they have to go back and restart the whole process all over again. I mean, it was just an awful story to hear.
Yeah, it can be devastating. Like I said, when it all goes where it's supposed to, when you know, hey, your child needs a guardianship, it's pretty clear and obvious. So you do it before they turn 18. Well, and usually, and then they're not fighting you on it. It goes a little bit smoother. But like you said, there are those cases where it's like, it's on the border, and they may decide say they don't think they need it, but you as a parent do think they need it. And if they're over 18, now you got to go to the court and prove whose side is correct.
Right.
And it can get really dicey because you're trying to prove that somebody you care about is, not competent enough to care for themselves.
Yeah, it's a different conversation when the child is 18 versus when they are under and still is a minor. And the timeline looks like this. And we're gonna share the recording back with Charles River. So if you'd be worried about looking at it from that standpoint, just know you can always get to this part of the screen, just take a picture or take a picture now in terms of it. But it's really about the sort of the triggers that happen, Craig, and age 16 is when we say that's when the process should really be. You can't start technically the guardianship movement, but you can put all of the pieces together. You can start gathering up any of the documentation, any of the stuff that's necessary so that when you know you are going to go forward with that, that you have it all together where you're not trying to. And I think that was the conversation that we had with the estate planning firm was
Mhm.
that they had delayed and waited and needed to get something. And then that's when the child then went from 17 to 18.
Well, the issue became they were looking for, doctor's notes on, his diagnoses.
Yeah.
Well, because he was over the age of 18, it was a HIPAA violation trying to get it. Where when he was still a minor would have been easier. So, like I said, if you can get all this documentation from the doctor's notes and medical records and anything else that you need to kind of put this through, and just assume like, I'm going to miss this wall. It's going to turn 18. I'm going to have to deal with all this stuff. Make sure you have all that stuff in place. It's well, it's easier to gather.
Right.
That's just gonna make everything go a lot smoother.
Yeah, absolutely. So just know, it's part of it in terms of understanding that the process can't start. but you as the parent can begin gathering up the documentation and necessary forms, like Craig said, the medical stuff and everything, all the pieces, so that when if the decision is there and you do want to do it, you can go forward because there is this time lag to get it done.
Mhm.
All right, so trust. This is where we get into the idea of a trust, right? And the conversation as to what the trust means, why it's important, why you should use one. You know, it's a legal document that separates the money from somebody else, right? The trust becomes an entity unto its own. This means if I'm putting money into it, I no longer own it. The trust now owns it. So the reasons that people use trust, Craig, this is fairly, high level stuff with this, right? Avoiding probate. Nobody wants to pay any more money than they do. That's settling out your estate so that we're clear that if assets are not designated in a clean or normal way, or like Craig said, there's no will, so nobody knows where stuff is going, then it goes to court and probate handles it. And probate is a cost. It's a fee that gets charged against whatever assets are held to settle that. And it takes, Craig, nowadays, like it's like 10 or 11 months nowadays.
Yeah, the other thing too that happens is anything that's not inside a trust that you own when you pass away is going to get listed in that, legal document to the public. And the reason they do that is because they want to see if anybody's got a claim against your property. So
Right.
it gives them a chance to say, hey, so now they get to everything you have, your Star Wars collection, bottle caps, everything you got, they're going to list it on that
Right.
document for public.
The management of assets for someone who's differently abled or has a disability, which is pretty much what we're talking about here for the aspects of it, but asset protection. Estate planning, again, this is minimizing how much I'm paying in taxes and charitable gifting, charitable planning. There are a lot of people who are inclined to want to leave assets to a charity and they designate those proceeds to a trust and the trust then pays out
Mhm.
depending on how they've got it set up. There's all sorts of different types of trusts out there, right? So I'm not going to name them out because they're all there in terms of what's available and the different things that they do and what they are. And there's no reason for us to go through all of them because ultimately what we're talking about here is a special needs or what is truly known as a supplemental needs trust. They're
Mhm.
interchangeable in terms of it. Some people refer to them as a special needs trust. Some refer to them as a supplemental needs trust. Same thing. I don't know why that did that.
Because it wasn't ready to be seen.
Yeah, clearly. That's weird. Like, what did I do with that?
There
That's
you go.
very funny. So you got three different types
It was
of
a teaser.
supplemental needs trust, right? Yeah, I don't know what happened there. It's just like ghost in the machine or whatever that is, right? So we'll go through each of these, a first party, a third party, and then the pool trust. We talked a little bit about this in the last presentation. We're going to go a little bit deeper in terms of the aspects of it here. See, there it goes. See?
Uh,
First party trust, right? So the first party trust is just what it sounds like. This is set up by the beneficiary. So the beneficiary is the owner of the asset. And in the case of when we're dealing with somebody who has a special need, who, as Craig said, is qualified and entitled to receive those government benefits, if they've received monies, that's going to trigger them to lose, suspend, or disqualify for their government benefits. So
mhm,
they have to take the money and put it someplace where that won't be a problem for them. And
mhm.
unfortunately, besides an able account, the only other thing they can do is put it into a first party trust.
Okay.
The first party trust will make sure that that money that's sitting in there is not going to affect those government benefits. Great. However, it's very, very limiting in terms of what the monies can be used for. They literally are only able to be used for basic living expenses.
Mhm.
There's a trustee who handles that, who's designated to deal with it, who can only let those funds be used for basic living expenses. And if all of the funds are not used, there is a payback provision. Medicare will step in and say, wait a minute, Medicaid, sorry, excuse me, will step in and say, wait, we paid out benefits. There's money left over. We want to get paid back for that.
Mhm.
So Why does that money wind up with the beneficiary? Well, sometimes it's a judgment award. They had a medical issue or an accident that happened. They got paid out on a settlement, and this is now a significant amount of money. Most of the time, not to throw Nana under the bus, but it's Nana because Nana leaves an inheritance and names all of the grandkids and does not know that she should not have named one of the grandkids because it's going to trigger a disqualification to their benefits.
Mhm.
No, nothing again, no disrespect to Nana, just so we're clear. The second type is a third party trust, which is what it sounds like. It's set up by somebody other than the beneficiary. The money that's funded into it is someone other than the beneficiary. This is usually parents, siblings, family members who are setting this up. Any money that's put into anything that's held in a third party trust does not count against those government benefits. It's a blockade. The trustee is set up to oversee it. That's usually a parent in most cases, is the trustee, Craig. But they have the flexibility on what the funds can be used for, so long as it's benefiting the beneficiary, is pretty much anything.
Yeah, it's a lot less restrictive than the first party trust, that's for sure. Yeah, because it's not owned by the person receiving the benefit.
Right.
And so it's
Yeah,
not controlled by them. So
correct. And setting up a third party trust cost comes into the equation. We talked about this a little bit the last time, right? So this area, Craig, what are we talking about? Like $5,000, $7,000, something like that?
in this area, somewhere around that, yep.
And assets that are put into a third party trust could also be charged for having the assets in there. So there can be an ongoing cost for any of the assets that are in the third party trust.
Like a management fee by the trustee.
Management fee, whatever, in terms of it, sometimes there's a minimum even in terms of what can be funded into there. So you just want to be aware of what's going on in terms of the trust. But if there are funds left, when the beneficiary passes, if there were siblings or a charity or something, you can designate a successor beneficiary inside the supplemental needs trust. There's no clawback, payback provision at all in terms of a third party trust. A third party trust is very, very flexible. You can pretty much put anything
Hmm.
into a third party trust.
Yep.
Real estate, stocks, anything just about you can put in there. So the ability to hold a lot of different things in terms of it,
Hmm.
it's just not necessarily the best things, and we'll talk about that in a little bit. The other thing we mentioned briefly last time were what are known as pooled trusts. And a pool trust is more about how the funds are managed than anything else. Your trust is your trust, whether it's a first party trust or a third party trust, it's your trust. That's whatever your designation, whatever it is, there's never any commingling to the assets. Your money is your money in a separate silo. It's handled under a trust arrangement. So the trust manages it. And that's how it's funded in terms of going through it. It's it's very good from a cost perspective. Let's put it that way, because it's fractional. It's like 10% of the cost to set up it's like what, $500, Craig, something like that.
Yeah, 500 or 600 bucks. Yeah, it's really inexpensive. But you'll also see why too. There's some limitations with it.
Right. And the limitations, as he mentioned, is the ability funding can only be cash.
Right.
So you can't hold those other assets. You can't hold stocks. You can't hold real estate. You can't hold any of that stuff in a pooled arrangement. Okay. The pool trust can't hold that. However, the biggest benefit to a pool trust is that the trust, the company is it's a nonprofit that's handling it.
Hmm.
And they can set up and become the successor custodian to the trust. And, we talked about what happens and why a power of attorney, and, you get later in life and you're now not capable of handling things, you become incapacitated. This happens to parents as well, that they're no longer able or can continue to be the trustee for their child's supplemental needs trust.
Yep.
But if there's nobody else to handle it, they're stuck. They're trying to find a trustee then.
Yeah. I mean, and the other issue with that too is sometimes they'll say find an attorney who's willing to do it, but the child could outlive them too. And
Right.
it may not be some, attorney may be a single firm or maybe have another partner who's willing to do it. So with an ongoing organization like this, you survive that single person as far as the trustee arrangement goes.
Yeah, absolutely. And then the other knock to a pool trust is it does have the same Medicaid payback provision as a first party trust. It's how it's built. It's not necessarily, there are ways to deal with some of that. Craig talked about it last time that you can set up and make sure that, burial expenses are taken care of and other things are handled out, when the individual passes before Medicaid can step in. So there's things to deal with, but from a standpoint of, hey, we're looking to set one up that $5,000 to set it up over here may not be available to us. This is an alternative.
Yeah, I mean, there's worse things that happen to have a clawback provision too. That just says that you had enough money in there for your child and there was something left over. I think that
Right.
would be what everybody would want to see happen
Yeah,
regardless.
right. They didn't run out of money. That's the
Right.
best case scenario.
Hmm.
So real quick on funding, right? Because a lot of we call this future funding because that's what happens a lot of times is we talk to parents and parents are like, well, I set this up. We just haven't put anything in there yet because we're waiting. We're going to figure it out as we go down the line and we'll see what's left at the end and then we'll designate that stuff to the trust, sort of the supplemental beneficiaries on all the accounts and everything and going forward.
Hmm.
So when we look at it, that not all assets being left into a trust are the same. The first one's the retirement assets. The Secure Act 2.0 made a change to this, which was a good thing. So
Hmm.
Secure Act 2.0 said, hey, if you leave your beneficiary is an individual who's differently abled or has a disability, they don't have to do the 10-year payout rule. They can actually stretch for their lifetime. So this is a good thing. This was a benefit that was passed as part of Secure Act 2.0. So if retirement assets are put into the trust, it'll be designated based off the beneficiary's lifetime, not off the trustees or whoever's put the money in. So
Hmm.
that's a good thing, Craig.
Absolutely.
The
Yep.
problem is that if you do this, you got to make sure you got the right kind of supplemental needs trust because you still don't want the assets to pay out
Hmm.
because even though they've got to take the required minimum distribution, you can do it in such a way where the trust just accumulates the money. It would be known as accumulation trust. The proceed pays out, but it actually funds into another account that's inside the trust. And so it never distributes. So it never looks like the child got any money.
However, the government's still going to get their piece. You're going to pay
Yes, it
taxes
still
on
gets
that.
taxed, and so that can cause a problem as part of it. So it just, it's it's there. A lot of times we hear parents say, well, it's just whatever's left in the account. I'm just going to designate that as the beneficiary.
Hmm.
The house, we talked about this. You can put real estate into a third party trust.
Hmm.
The problem with that is the house has, it's this morphine entity, right? It's got real estate taxes that never go away. It's got upkeep that never goes away. Forget if there's a mortgage on it, because that makes it even worse. But these are all things that need to get paid on an ongoing basis.
Hmm.
And what happens is ultimately is yes, the child's comfortable there. We want to leave the house to them. They can be there. But eventually we see trusts that end up house rich and cash poor.
Right. Yep. And you got to find a trustee who can manage the property as well. Right.
And eventually it's going to come to the fact that the property has to be sold and then the child's got to move. And then that whole creates a whole different conversation in a time when you're not there.
Hmm.
Securities similar to the retirement plan. People talk about leaving stocks or mutual funds or something into the account. And while, yes, that can be beneficial, the market is the market does, right? So there are whims of ups and downs, and who's knowing, and wait, I've got to get something out. I need to buy this thing, or I want to sell this, and who's doing it, and the oversight that goes along with that, and tracking it and making sure that it's done on an efficient basis. And while there can be times where that can become problematic.
Yeah, and as you said earlier, the more complicated the assets inside your trust, the more you're likely to be charged to manage those.
Right. And the more problems that can occur and the more drainage that can happen and the less money there is ultimately in the long run.
Mhm.
So a lot of times we talked a little bit about this last time about, the efficiently funding a trust. For us, one of the only ways you can really do that, like I can designate and know that, hey, if I pass away next year, that this amount of money is going to be put into the trust. It's using life insurance.
Mhm.
I can designate and know 250,000 is going into the trust on the time I pass, regardless of what I've spent, regardless of what else I've done, that can happen.
Yep.
And one of the biggest things with this is it's sort of when you think about it, Craig, from that aspect, because a lot of times when we're dealing with this stuff, it's like, well, I have this money, but I don't really want to spend it because I want to leave it to the next generation. Whether we're talking about a supplemental needs trust or a typical child, this is a conversation with parents that's like, well, in my mind, I've designated some of this money to go to the next generation.
Yeah, and the issue too, I think, is the connotation that comes with insurance, right? A lot of times when you use the word insurance, it's relating to things you didn't want to have to pay for. Auto insurance, homeowners
Right.
insurance, medical coverage, right? So it seems like, oh my God, they want more money for more insurance. But in this case, it's really about leverage. This is what the wealthy people do. They use leverage, turn a little bit of money into a lot more money, and have the confidence to know that if something should happen, things are funded, right? So the issue is if you had to put 250,000 cash into the trust tomorrow, where would you get that money from if you died? Is it available? Here, you can make a small payment on your insurance policy each month or each year, however you want to fund it. And that money is completely funded from the first day. So if the first premium you made was $50 and you died a week later,
All the money goes
250,000
in
goes
and
into
it
the
goes
insurance.
in tax free.
Right, right. So it's a very, very powerful tool for people.
High level, just give you an overview of how that works, right? So it's basically the trust. In some cases, the trust can own policy, in which case it takes it out of everything.
Hmm.
But you can set it up however you want to set it. But ultimately, when the proceeds pay out, the money goes to the trust, and the trust then is receiving the assets and paying it out from there. There's different ways to structure it and different ways to be efficient about it and how you want to have it. But ultimately, the beneficiary on that policy is the trust. And then the trust is responsible for dealing with everything and takes care of the child for the rest of their life.
Yeah, this system right here actually keeps it out of your estate for
Yeah.
estate tax money purposes. So
Right.
everybody's situation is a little bit different, but this is just one way to do this.
So beneficiary, we talked about different ways that assets transfer, right? And thinking about, how that happens. And we told you that, beneficiaries override a will.
Hmm.
So you want to make sure that all of your beneficiary designations, whether that's a life insurance policy, an IRA, the current retirement plan at work, whatever it might be, that that's designated how you want it to be,
Hmm.
what you want it to be, because that's going to override everything. And we talk about this that, reviewing it every couple of years, every 3, 4 years, taking a look at and just make sure the people who are the beneficiaries are the people you want as the beneficiaries. And making sure that if you have set up the trust, that the trust is listed as a designated beneficiary.
Yeah, and a lot of times too, people will get together, they'll get married or whatever, and they'll find out, years later they never changed the beneficiary on their retirement account. Right?
Right.
It's still mom or dad. Um, or the one they may have passed away from that point. There is no, it's going to the estate. So this is something that's really simple to fix while you're alive, very difficult to manage afterwards.
Yes. And that carries forward to everybody because, see, like I said, this is what happens. And when assets transfer to somebody, the child who's entitled to benefits, qualified for them, and then they get an inheritance from somebody because there wasn't, Craig, a lack of communication, a lack of understanding, a lack of being aware of, hey, no, we've got this trust set up
Yeah,
So if you want to leave money to, the son, the daughter, please instead name the trust as the beneficiary.
right. Hmm.
Best of intentions, just not realizing that the asset that gets received suddenly disqualifies them from any benefits that they were receiving.
Right. But like I said, these are not necessarily conversations you usually have around the Thanksgiving table, right?
Right.
And so, talking about money in a good day is difficult. And then talking about all the other implications that, oh my God. But
Now
whatever,
you're having tech
not
issues.
bad.
Look, we
I
had tech
am.
issues and now you're having tech
I'm
issues.
Max Headroom. Anyway, so yeah, so it's just a matter having good communication, like Tom said, is crucial to making sure that things go the way you want them to go.
Right. And really when we start talking about estate planning, it's really about thinking of the terms, and we talked a little bit about this last time. The concept here is you're trying to plan out the rest of your life while also trying to plan out and protect the rest of your child's life. This is
Hmm.
very difficult. This is very daunting. Most people it's challenging just to deal with their own life. Trying to do that for two becomes very, very challenging. So the idea is thinking of this from that aspect of the estate plan that's going to work in your favor, but it's also going to take care of your child at the same time.
Hmm.
And, again, it's a lifelong process, right? It's never really complete. It's ongoing in terms of what you're dealing with. The recommendation, Craig, is usually to revise or look at the will, if you've done a will, every couple of years, right? Like every 5 to 10 years, just to make sure that it's up to date, that everything is clear on it, that you have everything that you want to have in there. But it's
Yeah.
also that it's following whatever updates have been mandated, whether it's state or federal.
Yeah, we were doing a presentation one time, and a woman comes up after the presentation and says, "What do I do about changing my will? I don't like any of the people who are in it anymore."
And that happens too, right? We all have issues in terms of dealing with family and everything else that's there. But just know it should, your plan should be revised every couple of years, but your will should definitely be looked at on an ongoing basis.
Mhm.
That's pretty much everything that we had for you tonight. Hopefully you got something out of this in terms of what's there. I will tell you what we do make available to everybody is an opportunity to have a one-on-one with us. It's complimentary. There's no cost for it. You're part of the Charles River Center's community. So we make that available. That's what that QR code is on the screen. I don't know if Melanie's in the background someplace, Greg, but or did she
Be
drop
back
the
there
link
somewhere.
in?
I don't know. We'll chat. There's no link in the chat right now, but
Okay, so um, if at some point, if you're not able to, if you're watching this as a recording, you can pause the screen, take your phone out, shoot the QR code. Hopefully that link gets dropped in there at some point as far as going through that. But it's also the link along the bottom of the screen there, which would be able to do that. It'll set up, will allow you to have an opportunity to meet with us. If it gets dropped in the chat, you can just copy and paste it any time that works for you.
mhm.
So if she's not there, I don't know if she also has the evaluation form.
Well,
I am here. The chat is just disabled to anyone but you, Tom. Sorry.
Awesome. That is great to hear. So see, the technology is just okay.
disabled. So what I would do, Melanie, is send the chat to him, the link to him, and then he can share it with everyone.
You can see it, Craig?
I cannot. Chat is disabled. I'm just another participant. Tech support.
Yeah, clearly. I don't know what to tell you there. So anyway, all right. Well, we'll just skip through that. I'm not having a good time with with anything to do with the
Oh, okay.
okay, never mind.
All
I'm
right.
not going to keep you playing for too long. So any questions for us? If you can take yourself off, clearly the chat box isn't working. So I'm going to stop the share at this point in terms of sorry, stop the recording here.
Yeah. But we have a hand up. Yes, we did.